Okay, let's talk about right to constitutional remedies. Article number 32. What this says is that the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this party is guaranteed. What this means is that any person who thinks that his fundamental rights have been violated can approach the Supreme Court for his protection. That's what it means. Clause 2. Clause 2 says that the Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. What this means is that Supreme Court can pass any kind of order. Writ is a kind of order. And these are five kinds of writ that Supreme Court can pass. We'll talk about them in detail in later videos. Basically, Supreme Court can pass any of these orders to protect fundamental right of any citizen. That's what it means. Third clause says that without prejudice to the powers conferred on the Supreme Court by clauses 1 and 2, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under clause 2. What this means is that not only Supreme Court, any other court can pass any of these writs to protect the fundamental right of any person, as long as those powers are given to that court by the Parliament. That's what it means. Next, clause 4. Clause 4 says that the right guaranteed by this article shall not be suspended except as otherwise provided for by this constitution. What this means is that unless it is specified in this constitution, this rights provided by this particular article, that is to seek the assistance of Supreme Court in protection of fundamental right, can never be taken away unless it is specified in this constitution. For example, Article 359, which talks about emergency provision, says that certain fundamental rights can be taken away in case of emergency, and it was upheld by the Supreme Court judgment ADM Jabalpur versus Shukla in 1976. But later on it was taken away. That means now that particular restriction is no longer valid. That means even in case of emergency, this particular fundamental right cannot be taken away. That's what it means. So basically now we can know that how important this particular article is, that only through this article the rights given, fundamental rights given to a person, are protected by Supreme Court. That's why B.R. Ambedkar said this article as heart and soul of Constitution.